right, we are here in the matter of the people of the state of Michigan versus Edith Corbett, case number 24-04823-FH, and this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court this morning on Ms. Corbett's motion to withdraw her plea or for judicial vacatur of the guilty plea. At this time, I would invite counsel to place your appearances on the record.
Blair Lockman for the people, Your Honor.
Thank you. And Ms. Dagger-Margosin, you are muted.
I'm sorry. I'm Janice Dagger-Margosian for Ms. Corbett.
Thank you, ma'am. And this is your motion. I did read through it, and it appears that the primary basis here is that the factual basis that was elicited during the plea hearing itself did not meet the elements of the charge that Ms. Corbett has pled to and is serving her time on right now. And that specific statute is accepting the earnings of a prostitute, MCL 750.457. And I did read through your brief and the prosecutor's response, and I guess my view of this, particularly in light of the appellate cases that set a somewhat relaxed standard for a judge accepting a factual basis, is I certainly viewed the entirety of the transaction that Ms. Corbett was involved in with these customers coming to the massage parlor as a transactional situation where the customer comes in, they pay Ms. Corbett the $50, allegedly for the room, but, let's be honest, under the facts of the case, it is for access to a room with a young woman who's going to perform a sexual act, and everyone has knowledge of that, and then, she accepts that money. It seems like a stretch to say that's not the earnings or proceeds of prostitution.
Can I respond, Judge?
You may.
Thank you. Well, number one, Judge, I think it's really important here. In light of, and I think the Maury case is really important, that you really do have to look at the language of the statute. Here, Ms. Corbett did not stand there and accept these door fees. So number one, I think the important fact is they were door fees. They were not money obtained from a sex act that was performed. And she was not present at the premises at the time she collected these fees. She collected them at a later time, at a different time, when these sex acts were not going on.
Well, let me just pause you. She wasn't the landlord of these premises. That was someone else. She leased the premises, and this was her business, right? Whether she was present for every moment, and certainly I think everyone agreed, well, she's not present in the room when the sex act occurs, but that rather it was a scenario where she knew and allegedly, perhaps, to some degree trained or, prepared these women for the nature of this illicit massage business, right? And further, I don't think that the statute doesn't say you got to be standing there and the prostitute commits the act of prostitution while you watch it and then hands you a portion or some of the money. It just says that the person themselves knows what's happening, and then they accept, receive, levy, or appropriates any money or valuable thing from that act. And I guess the other piece of that is without any consideration given to the person, presumably I'm trying to figure out what in the heck the statute means by consideration here. And the only sense I can make of it is, you're not giving any consideration back to the person who performs the act, but rather you're just taking the money or a portion of the money that comes results from the act in a broad sense, the proceeds or earnings. So I mean, I guess, and that's really my thought in looking at the statute entirely is you'd like me to, impose like a sequential order that has to happen in time. And the statutory language to me reads much more broadly than that. It says, hey, if you get your hands on some of this money and you know where it's coming from, you're liable, that's what imposes jeopardy under the act. Am I reading it too broadly?
I think so, Judge. Respectfully, I think that, and this is what happened in the Maury case, is the Supreme Court looked really, really closely at the words of this statute. I think here you would have to have a situation where Ms. Corbett was receiving money from the prostitutes and knowing at the time she received it that that's what it was from particular sexual acts. Here we don't have that. We have a very generalized set of door fees. So I think the area we're treading into is what
Maury
the
was a little
prosecutors.
different though, because it was the person was more or less who at least, and I didn't read, I just read your summary of Maury, but it sounded like that was a scenario where the person was receiving the calls and then directing the customers to a location to meet with a prostitute. And if there was any money changing hands, it would have been a separate transaction or not, and in that, is that the kind of the
Well,
background of Maury?
I think, and I summarized Maury as well as I could for you in the brief, but I think the important part of Maury and what happened at the Michigan Supreme Court level is that that court said every single word of that statute has to be observed and complied with by the courts. And we can't, this is the kind of case where you could make inferences upon inferences upon inferences, which the prosecutor relies on in the brief, talking about inferences. But number one, this is a plea, so you got a due process concern of making sure, because you're not having a trial, you're not having a jury find these facts, that the defendant is establishing this guilt. And number two, where the inference upon inference, the old rule of Attlee, I believe it was loosened up in a case called Hardin in 2002, which still said you must have findings that are based upon evidence. You can't speculate. And in this particular case, we're in the realm of speculation. There were door fees collected. Ms. Corbett was not there to collect those fees. She didn't know what was happening in those rooms. There may be times certain things didn't happen. You don't have a transaction where a prostitute goes into a room, does an act, comes out, and turns over her profits. And I think that's, this statute, I think, derived from the times when there were where
Brothel.
prostitution was developing.
Right.
And so you had pimps that were taking fees one-on-one. You don't have that in this case. You have a very generalized setting that she made available. She didn't know what was happening in those rooms. The statute says knowingly that the acts must be profited from knowingly. She didn't do that. She provided a premises. It was known that in general this happened, but she didn't have a one-for-one knowledge that the money she accepted was happening. I don't think that there can be a reasonable inference here. I think you've got inference upon inference upon inference, and I don't think that has any place in plea proceedings, Judge. That's a violation of due process. So that's the summary of my argument.
Well, her own attorney asked her, and I'm on page 9 here of the plea colloquy. Mr. Fabian, you're aware that at least one or more of these independent contractors would perform sexual acts during the massage and in exchange for money.
Correct.
Corbett, yes, sir. I mean, how's that not acknowledging that she knows what's happening in those rooms, whether she's on the premises at the moment or not?
Well, but I think that again, what we've got here is a generalized situation. So she is stating that she knows generally this happens. So that would certainly, we would agree, supports having a house of prostitution. She knew this happened, but she wasn't taking earnings as they occurred. She took a very general door fee. The women that did this work got some kind of tip. We don't know how much was tip. We don't know how much was door fee. This was not placed on the record. And so I think that where you have to have some kind of specificity with a plea that complies with the statute, we don't have the knowingly element and we don't have the transactional element. I think those things are clearly missing here.
Okay, all right. No, I think I understand the argument. Let me see if Mr. Lockman has any response in addition to the brief filed.
I would just note, under that theory, we would never be able to do this charge, because there should argue that they have to know specifically that every dollar that comes in is for this, and that's not what the statute contemplates. I think the court hit the nail on the head. It's right in the brief. She acknowledged that these were independent contracts performing sexual acts during the massage in exchange for money. I don't know how you get more specific than that. And I don't think the courts require more specificity than that. And then she admitted that she collected a fee from every customer that entered there for, in quotes, massage service, which she was aware in many cases were for performance of sexual acts. I think this is, I think it's someone who, after sentencing, has decided they didn't like their sentence and is now looking for a way out and finding this defect. This is not a defect. This is a very clear factual basis that she knew what she was doing, and accepted that fact when she took that plea. And now she's just having buyer's remorse.
Okay, all right. Thank you,
Your
Mr.
Honor, if I could just place on the record, I appreciate that. I hear that from prosecutors pretty often. We don't have any evidence that this is buyer's remorse. What this is someone who had the right to have an attorney overlook her case and view it and see if there are possible issues that were overlooked at the trial level. I don't think disparaging my client is appropriate here. So just want to address that.
Oh, no, I understand. And of course, my entire job is to make sure that, each person that comes in front of me gets the full range of procedure they're entitled to. And a hearing like this is just that. So I don't attribute any of it to, some sort of ill intent on behalf of your client. I know, and I know that you're simply doing your job here as well, and going over the proceedings, as it needs to be done with a magnifying glass to make sure that I get it right, because heaven knows. I was just thinking the other day, when I elected, one of the promises I never made was that I would be 100% perfect judge. I just said I was going to, fulfill the oath to the best of my abilities when I'm on the bench. And I appreciate the ability to, legally consider what I'm doing here. However, I will say in this case, I have read the briefing and reviewed the statute, and I don't find a basis for withdrawal of plea or vacatur of my judgment. That would require, finding of a fatal defect, as it were, in the plea proceeding. And essentially, the defect alleged here by Ms. Corbett is that, Judge, you're allowed to draw some inferences in the factual basis of your plea, but you went beyond drawing an inference. You went to rank speculation, as we would call it in the legal world, as to what Ms. Corbett knew, and further as to the sequencing or the economics of the business that she rendered or that she operated on Plainfield Avenue in Grand Rapids, or Grand Rapids Township, as it were. And the statute at question here that Ms. Corbett entered a plea to was Michigan Compiled Law 750.457, which reads, any person who knowingly accepts, receives, levies, or appropriates any money or valuable thing without consideration from the proceeds of the earnings of any person engaged in prostitution, or any person knowing a person to be a prostitute, lives or derives support or maintenance in whole or in part from the earnings of the proceeds of the prostitution of a prostitute, is guilty of a felony. And I agree with Ms. Dagger that statute probably comes from an older time when the law contemplated, perhaps the classic pimp who's out there with a stable of women, and the woman is involved with prostitution. The pimp perhaps provides banking protection, but also appropriates a portion of the money she receives from prostitution acts. And that's not what happened here, though certainly. Like the classical situation, Miss Corbett did provide, the location, the surroundings, and I think that at least during a portion of her own allocution during the sentencing process indicated that part of her basis for doing this was she had been involved with or observed another business that didn't provide what she viewed as adequate protection for the women that were involved here, and perhaps allowed the customers to pressure them or persuade them to perform additional sexual acts that she thought was unsafe and improper, and so she builds a different business model, as it were, that she believed provided more protection for the women involved. Now, and as I said during the sentencing, the law doesn't make any distinction between sexual acts, and we do have case law out there that says, of course, sexual acts, include manual stimulation, as appears to be the primary sexual act we're talking about in Miss Corbett's situation. It's a very broad definition, and I think that broad definition, of course, in performing what we call statutory interpretation, it's important to read the statute word for word, and I agree wholeheartedly with Ms. Dagger. Part of that is giving effect to each word of the statute, and then trying to discern what was the legislature's intent when they passed the statute, perhaps in an outdated time or before, we had stuff like the internet and instant messaging and stuff like that that changed every business model, not just, a business model for prostitution. And in this case, the statutory language is actually quite broad, because it says that any person, and it gives also a broad definition here of how that person receives a financial benefit. They accept, they receive, they levy. Levy, of course, I associate with taxation. Of course, that's not what happens here, but nonetheless, they're or appropriates, i.e., that would be the appropriates. The pimp going to the prostitute and saying, "Hey, you hand over the money to me." That's not what happened here. However, in a transactional sense, and I also look down here, the person takes without consideration. That is, they're not giving anything necessarily back of value to the individual who they get the money from the proceeds of the earnings of any person engaged in prostitution. Now, read in its absolutely most narrow sense, that could include a time factor, in that the person has to commit the act of prostitution and then hand the money over in that classic pimp model that I talked about earlier, which was not what happened here. Here, the timing sequence of these men patronizing this business is they come in, they pay the money to the house, the door fee, for the room, for access. Well, and let's be honest here, they're not renting a room, to use the computer in that room to do drafting and print out a 3D model or something. They're renting a room with a bed or massage table or something that they know contains a young woman who they believe, because of the way that they learned about this business, will provide a sexual act. And Miss Corbett did testify, she's aware of that. Was she aware of the exact act and the back and forth between the customers and the woman in the room? No, but she was aware that there was money exchanged in those rooms in return for sexual acts. And I think that taking the broader reading of this, that the earnings of the person engaged in prostitution, well, after all, the reason that the men are coming to the business in the first place isn't to get that room for an hour, isn't to lie in the bed for an hour and talk to the woman. They are coming in to at least in some instances, and it doesn't have to be every instance. In fact, it probably only has to be one instance to fulfill the statute. In at least one instance, the person is coming in and engaging in an act of prostitution. And in my view, in light of the way the transaction occurs here and the use of the word proceeds in the statute, there's a broader transactional view here, and that in terms of the customer coming in, they're going to pay $50 and they're going to give whatever they give to the woman inside the room, and the entirety of that is to facilitate or enable or make happen the act of prostitution that occurs. And I believe that is a reasonable inference for the court to make during the plea colloquy and during the um, uh, uh, acceptance of the factual basis for this conviction here. So I don't think, in other words, that there is a time sequence that the proceeds have to be given first to the prostitute and then the prostitute has to give some to Miss Corbett. I believe that the overall basis of the transaction, even though that's not clearly spelled out in the statute, is one that facilitates prostitution, and that the earnings that were paid to Miss Corbett, that is for the room, the access to the woman. And after all, she didn't just say, hey, I set up this business with 3 rooms in it. And, there happened to be women that came in here and wanted to do, massage and et cetera services. But rather, her testimony was she formed this business for the purpose of, creating this environment where, the sexual act was provided in a way that she believed was safer for the women. So I don't think that I over read or applied the statute overly broadly in this case. I think the statutory language can be read and should be read as encompassing this entirety of this transaction that involves, after all, at the end of the day, it is transactional. The customer comes in, they pay money, albeit to 2 different sources, one for the room, one for, perhaps more money in the directly in the room, negotiated with the woman in the room herself. But nonetheless, the overall transaction is one that facilitates a sexual act in return for money. And Miss Corbett knew that was occurring. So I don't think that is an overly broad reading of the statute, nor do I think it supports the type of defect that would allow vacatur of the plea by me at this time. Thus, I'll allow the plea to stand and the motion is denied.
Thank you, Judge. 2 things. I'd be glad to do the order and submit it to you for signature, the order for denial.
Very well.
And then I can serve that to the prosecutor if that's acceptable.
We presented just a general order. It's just a standard blank.
You want to do that? Okay.
It's the court already has it. Yep.
Oh, it is. Okay, good.
Yep.
Okay, so the order's taken care of. Number 2, could I have a few minutes with Ms. Corbett in a breakout room, please, before we sign off?
Certainly.
Okay.
Talk to my lawyer for a second. Thank you, sir.
Thank you.